Shilpi Bhattacharya, very warm welcome to Digital Markets Research Hub. It's always a pleasure to meet you. You belong to this category of academics who understand perfectly the function of competition law and policy in the broader context, in the global context, in different jurisdictions, but you specialize mainly in Indian competition law and policy, and you know the mechanics of the processes in several important industries. And our main focus is digital markets. And India is known in many respects as one of those jurisdictions which show remarkable trends in terms of the function of markets themselves. They show really rapid dynamic and some very original features, but also it joined the club of those jurisdictions which think that the traditional competition law is not sufficient, that the digital markets require special regulation, special treatment. And so I propose maybe we can start with just your snapshot of the development of digital markets in India. What are your main observations about the trends, the maybe some specific features which are peculiar only for Indian context?
Thank you so much, Oles, and it's such a pleasure to be here talking to you again. Thank you for having me, and also because these discussions are so thought-provoking, and it's helpful to step back sometimes and take a broader look. Because as people working in competition or from a more scholarly perspective, we do have, in general, a more narrower view. We are looking at things from the perspective of the research we're doing or the teaching we're doing, and these broader questions are helpful to give us to allow us to take a step back and see what's happening. But also, I was just thinking about this, that digital markets have forced us to start taking broader views of what's happening, which as competition lawyers, normally take a case by case perspective, a market perspective. But this change in the change in regulation, or the attempts to change regulation, are forcing us to have a different perspective as competition lawyers and people working on competition law. So in India, I think, I mean, we've discussed this before. India is obviously is a growing market. It's a dynamic market. We have a very young population. People are very interested in moving towards the digital realm. And it's a great place to be for any business that is digital, because of the sheer numbers that are there in India. So from a consumer perspective, India is definitely the place to be. And from a entrepreneurial perspective or the supply side perspective as well, India is growing. Lot of new companies are coming in, and this sort of entrepreneurial culture, which is what motivated the Competition Act to come about in the first place, because we didn't have that in the 1990s. And that's what was the need of the hour at that time, and that's what motivated Competition Act, is now coming into India through the startup culture. So a lot of people are interested in starting their own ventures, especially with the low entry barriers or the low startup costs in India now. So even a lot of people will know people who are doing startups now in India. So this is now becoming quite a craze, maybe, to have a startup. So on both sides, on the demand and the supply side, India is quite dynamic. But at the same time, we've seen over the past few years that now, like 2 or 3 years, I'm saying, like just in the immediate past, that there is a note of caution that has come into the digital markets in India. Funding for startups is stagnating. People who are funding these ventures are more cautious, and there have been a few startups that have not worked out well. So it's a little bit now a stage where there's consolidation. There's a little bit of a more careful approach towards sort of newer companies that are coming in. But obviously a lot of change, a lot of development. And this is also something that's very much part of the discussions in the competition law world, which is we need to protect this kind of startup culture. So the startup culture is now a buzzword, and everyone wants to wants to protect or wants these companies to grow, but what is it that we're really trying to protect or trying to achieve? It remains unclear, because there isn't a more substantive discussion in terms of what these startups are doing. And if you really drill down to it, how innovative are these startups? How much are they really changing the lives of consumers? How much are they adding value to consumers? Those are discussions that we need to have, that we're not having enough of.
Let's offering a continuing with descriptive kind of exposition of the Indian digital markets. We have, some would say stereotypical, some would say self-evident vision that the structure of digital markets, whichever core platform service you take, whichever jurisdiction you take, it would be either monopolistic or very, very tipped, with big tech being the pivotal players. Let's say startups is good. Each jurisdiction is proud of their startups, but the scale matters supposedly. And so what is the situation in India? I understand the digital markets are different. There are many different services and products are being offered, and you can categorize them differently. But do you observe similar structural features? Is it very prone to monopolization and that with all the network effects and implications of entrenchment? And maybe you can describe to us the key players, if they are not a traditional kind of, are they traditional GAFAM companies, or you have other companies, local or from other neither Indian nor Western jurisdictions?
Yes, so absolutely. In the key digital sectors, which are also the sectors where we see more enforcement happening, search, mobile operating systems, social media, you see the big GAFAM companies in India, right? So Google, Android is the most common operating system. Apple has not had that level of penetration in India, so it is Android only. There have been partnerships with respect to Google and other Indian companies, but Google is the dominant player in India. Meta is the dominant player in India on social media. We don't have TikTok because the government has banned TikTok, so it's only Meta is the main social media player in India. For some of the other sectors, we do see some level of local players. So, for instance, e-commerce, we have competitors to Amazon, which is the Indian company Flipkart, which is owned by Walmart, but also in a lot of like the niche e-commerce spaces, we have a lot of Indian players. For instance, in fashion, we have Myntra, we have Ajio. These are all Indian companies. For things like taxi aggregators or ride aggregators, we have Ola, which is an Indian company, which competes with Uber. Restaurant aggregation, we have Indian companies, Zomato, Swiggy. In travel aggregation, we have an Indian company leading the market, which is Make My Trip. So in a lot of the pet, and then ed tech, we have Indian company Baidu. So in a lot of the peripheral sort of e-commerce intermediation services, we do have Indian companies, but the core digital services, the platforms are still very much GAFAM oriented, and the economics of it is still very much the same. So you do have like one or two major players in each sector, and these players do have a lot of power. There has been some enforcement, for instance, against Make My Trip, which is an Indian player, but there hasn't been much competition enforcement in India. So 4 cases, 3 against Google, one against Make My Trip, is the maximum extent of enforcement. That also is still not finally sort of not reached finality, still in appeal before the Supreme Court. I mean, the economics of it, just to kind of summarize, the economics of it is the same. But we do see, for instance, in ride aggregation, Ola and Uber are the two major players, the taxi players. But you do see now smaller companies coming into the market. So, for instance, we have Blue, which is an electric vehicle company that's providing ride aggregation. And then you have companies coming in niche areas. For instance, they're saying that you can negotiate your fare with the driver. You don't have to accept the fare given by the driver as you have to do in Ola, Uber. So you have those kind of, like, you see more competition now coming into this space. So there are like some markets where which are more competitive, but I think the core digital markets, there isn't much competition there.
And because India is in the production of digital markets, of its own Digital Markets Act, its own digital market regulatory ex ante regulatory regime, I was wondering, what are your sensors telling you when you monitor the discussions, when you interpret the discussions? Can you somehow identify several approaches, several visions, several energies, or kind of policies underpinning this legislation? What would be the strategic interests of Indian digital markets, digital society, digital market players through the prism of this new legislation? Is it about bringing more transparency to the market players? Is it more focused intra-ecosystem, intra-gatekeeper, or it's about changing the players or changing the ways how the main players offering their businesses?
So this is a great question. I think the draft digital competition bill has really created sort of some kind of shift in the discussion around competition enforcement in digital markets, because at least for me, just as a witness to these debates that are happening, there's definitely something that I'd like to point out, which is the degree of polarization that's happened in this discussion, right? So there's a majority view that is that the digital competition bill is the worst idea possible. Someone said that there's nothing good about this, like there's absolutely nothing good that can come from this bill. The only thing good about this bill is that it is a bill and it hasn't become a law yet. And then obviously there are people who say that this bill is needed, including the people in the committee that recommended the bill. And there are obviously others who also support the bill, but I would say the vast majority of lawyers, at least, are not supporting the bill from what I've sort of witnessed in the discussions. So the bill is obviously motivated by and I think this has been one of the consistent kind of policy approaches of the government, which is that we want to exploit digital markets and we want them to remain open. So you see that in ventures like the Unified Payment Interface, or the UPI, which is an interoperable payment interface, which has allowed sort of new players to come in. Although Google is still sort of leading the pack with UPI now, but still it is sort of a very interesting interoperable framework. Then you have the ONDC, which is an open network for digital commerce, which is again trying to make e-commerce more open. So I think the Indian government does have this policy objective that they want digital markets to be open, and that will be the way by which we can exploit and make the most from the digital markets. And I think the bill is part of that agenda, to keep digital markets open and also to promote startups. So there is a push towards promoting startups, and the bill is part of that agenda. So I think that's the broader framework of the bill. But there's a lot of discussion around the fact that the bill will stifle startups, and will reduce the level of investment coming in from abroad for startups, for Indian companies, and also there's a fear that companies like Google, the GAFAM companies, will change their business models in India, and India will not get the benefit of innovation from these companies, and that competition will and consumers will ultimately be hurt by the bill. So those are the primary sort of narratives that are coming out from sort of the other side of the critique of the bill. But obviously, the bill also needs some refinements. It is very broad. It isn't exactly clear as to who will be a part, who will come within the ambit of the bill, because the thresholds are low. So a lot of players that are not GAFAM companies will be, as the thresholds currently stand, I think I read somewhere that maybe 100 companies could get designated under the bill. So that is also an uncertainty. But a lot of startups are also supporting the bill. So there has been sort of this to and fro coming from some of the startup community and some of the sort of opponents of the bill, saying sort of this interesting discussion, but it's also a little bit polarized. So it's quite an interesting time to be in India.
Yeah, we have similar narratives shaped by the proponents and opponents of EU and UK legislation. We also hear that investment will stop and that innovation will stop, and the companies will abandon 1.5 billion population market. Yeah, it's and more evidence is needed. All these issues have been thematized and very colorfully presented during the discussions in the UK and in the EU as well. So it's very unsurprising that these narratives are being used further. And some of them obviously have more merits than others, but leaving aside the judgment. But I wanted, before looking at the bill itself, we hear more and more attempts, or at least to thematize, not to implement, but at least to thematize and understand better some kind of public digital approach to structuring the digital components of our society. And India has several initiatives, very successful initiatives, for those who would expect homogenization and standardization, and maybe a little bit scaring in terms of their successfulness, initiatives for those who would be very cautious of side effects. But leaving aside normative issues, I wanted to ask you about the mechanics of UPI, Universal Payment Interface. Many people talk about it. Please explain, what is it, what are the purposes, what are the main problems with this UPI, and what it delivers?
Okay, so I'm not a very technical person, but so I'll give a very sort of layman's perspective as someone who's using UPI. So essentially, what UPI allows you to do, it's a way by which you can make payment, business to consumer or consumer to consumer, from different banks. So it doesn't matter what bank you have, what payment system you're using. You can make a payment between sort of a person using a particular bank or a particular payment wallet can make a payment to someone using a different payment wallet. So the idea is that your choice of payment wallet, your choice of bank will no longer depend on how easy it is to make payments to others, in the sense of sort of, are you also using the same bank? So earlier, so if I'm using a particular payment wallet, I can only make a payment to someone using the same payment wallet. So everyone would then sort of power of network effects use the same payment wallet, but with UPI, you don't have to do that. So you can, it doesn't matter what payment wallet you have, you can make the payment and it's seamless. And in general, it's been working really well. Almost sort of, I have never faced any real issues with making payments in UPI. It's very popular. UPI is the one of the most popular ways of making payments. Almost everyone has a UPI account and they make payments through UPI. So it's become really easy, and also sort of the whole idea of sort of having a cashless system. I think UPI is the best way by which that could be achieved. We still don't have a cashless system in India, but I think it's gone pretty significantly in that direction because of UPI, because credit cards would not sort of work in the Indian population given just the level of income that people have. not everyone would be eligible to get a credit card, but UPI is a way by which you can have cashless payments. So it's definitely allowed businesses, smaller businesses, to accept payments in a number of different ways. So it's good for smaller businesses like the local retailers, etc. It's good for individuals who are doing business. And in general, has really helped, I think, a lot of the smaller players to sort of access digital markets. So UPI in that way has been really game changing.
And in this context, is it public initiative has been was it developed organically or introduced in a more interventionist fashion? And also another service, India Data Universal Digital ID. Universal
Yeah.
Digital ID. What is it, and what is its function and implications?
So UPI is definitely part of a government initiative, not organic. So done through the National Payment Corporation of India, which was set up for this purpose. The NPCI kind of regulates how this happens, and then ultimately the RBI, the Reserve Bank of India, is the broader regulator of payments in India. But so this was done consciously to make Indian markets more open in terms of digital payments. And this is a very specific sort of government intervention to make this payment mechanism more open, more competitive. So it's definitely a very conscious move. It's not an organic move, but the way it's taken off is obviously because of the way that players have kind of entered into this market and kind of provided these kind of services. So that has been more market oriented, but the establishment of the UPI was done by the government, and then you have various private players providing these, using the UPI to provide payment services, and that market did take off. But obviously, the government provided that infrastructure for that market to take off. And then obviously you have the government's own attempts to move more digitally through UDID, Aadhaar, and that is more for provision of government services, um, um, for more public oriented sort of use of digital infrastructures. And I think the government is sort of pushing for that. So they do sort of mandate a lot of, like, you have to use Aadhaar for to get a number of services. You have to use Aadhaar for authentication purposes now. And sort of they're also, it's both a mixture of mandating that you need to use Aadhaar for a number of things, as well as saying that if you use Aadhaar, these are the benefits that you can get. So there's also like a carrot approach to it. So so that's another sort of side of it. But Aadhaar also has certain issues, especially just in terms of the data that is being collected. How secure is it? How safe is it? What is the government going to use it for? At least in my very personal view, those are concerns, and obviously that should be a concern for any data collection that's happening. But because Aadhaar is being used so extensively for literally every single thing that we do, from sort of health related services to any other sort of government service, for our banking, for our telecom, etc., any kind of authentication, we have to use Aadhaar. So it's easy to track through Aadhaar now. Aadhaar is a good way to track people. So that is a matter of a little bit concern. But obviously, like all collection of data is a matter of concern. But the more data that you have, also that'll be a bigger concern.
With respect to tracking and surveillance issues, I think it goes beyond the focus of our discussion, but where I see the potential interest, let's say, is the issues of advertising, of online advertising. And you mentioned that among the core platform services, Indian markets for online advertising shows some presence of not the traditional, the local players, let's say. So I wanted to ask you if you observe, do they do the same? Do they build the same digital infrastructure, ad tech infrastructure as the traditional players? Or they come up with something different? Because now we see such big level of entrenchment, and one of the directions of the discussion is it possible to build it differently, or we just doomed to copy paste the ad tech empire, which has been already meticulously created by, or let's say, a programmatic advertising model which has been created and functioning at the moment.
So if I mentioned that, did I mention that we have our own ad tech? Because if I did, that's not correct. I didn't mean to say that we have our own ad tech stack. We're definitely sort of Google is the major ad tech provider in India. But there was some discussions of Google tying up with companies like Reliance, especially because Reliance, which is one of the larger Indian conglomerates, had this ambition of being the cheapest smartphone provider in India. So they wanted to launch these extremely cheap smartphones, and then they realized that they to do that they had to have a very obviously sort of the operating system layer, which would obviously also have to be very inexpensive. And for that, they tied up with Google. But then they ran into issues with respect to the semiconductors because of the issues in the semiconductor market. And then I think they could not, I haven't followed up fully on why that couldn't sort of launch in the way that Reliance wanted to launch. But last I know is that there were issues in the semiconductor market, which made it difficult for them to meet the cost threshold that they wanted to meet for the basic smartphone launch. So they, just a little bit above a feature phone, right? That's what they wanted, something that a lot of Indians in rural parts of India can afford. And then they will basically have just a very few basic set of apps on that phone. And maybe like Reliance would put its own apps, because Reliance is present across every level of the stack, from being the telecom provider to being sort of e-commerce provider to being entertainment provider, etc. So they can then sort of add their apps to that phone. I think that was the business model. But they didn't take off. But I think as part of that, they also wanted to get into advertising. I think Reliance definitely wanted to get into advertising, but they haven't been able to sort of collect that kind of data. You need to have that kind of large platform to provide, to get into that tech stack. Otherwise, competing with Google is not possible, just given the advantages that Google has in terms of both access to consumers on the demand side, as well as the kind of data that they have. Competing with Google in that tech stack, I don't think is that easy.
E-commerce. You also mentioned that you have a local player of a comparable size or scaled up player with connections to Walmart. So in this regard, do you see, do they compete with pretty much the same, offering this competition on improving their services and what they offer to consumers and businesses, incrementally adjusting, refining, and making them a little bit better, smoother, quicker, cheaper? Or they come up with some strategic differences which go beyond quantitative and are of more qualitative nature in terms of business models?
So Flipkart, which is I think the biggest competitor to Amazon as a overall platform for e-commerce, I don't think it is differentiating itself qualitatively from Amazon. I think it's essentially on price. The competition is on price and maybe on certain kinds of products that are being sold. So Flipkart is more popular for certain types of products. Amazon is more popular for others. Flipkart also has good penetrability into sort of the rural parts of India, or the less sort of metropolitan parts of India. And also being an Indian company, although they are the founders being Indian, they do have sort of a view of the Indian market. So I think that also helps. So Flipkart and Amazon, I think, are not very distinguishable from a qualitative perspective, but you do have the other sort of in the more niche areas. So, for instance, Nykaa is e-commerce player. They started off essentially for makeup, and then they've moved into clothing. And I think the e-commerce market for clothing is very competitive. In India, for smartphones, I think it's or electronics, it's mainly Amazon and Flipkart. But the other areas are more competitive, like clothing, etc. So there you see sort of more innovations happening in the more competitive markets, obviously. For digital products, I think it's mostly competition on price, and the deep discount, they have these days when they provide deep discounts, and everyone buys their digital products at that time, phones, etc., on those days, on the sale days. And so that's how those players have been able to entrench themselves, Flipkart and Amazon, deep discounting essentially. But in some of the other markets, we do see some interesting e-commerce players coming up, sort of finding niche markets, operating in more interesting ways, providing products in a more interesting way. For instance, one of the innovations in this space has been quick commerce. I'm not sure if you're familiar with that. So 10-minute delivery. So for groceries, right? So earlier you would have to plan your grocery and then like order, but now you have a number of companies that are providing 10-minute delivery, and they're becoming really, really popular, and they're really challenging the status quo of these kind of markets. So even players like Amazon, which do also have grocery verticals, but they're not able to compete that well with these specialized quick delivery, quick commerce services. And they're starting with grocery, but now they're moving on to electronics, to gift items, to so they're gaining market share in these spaces. And people didn't think that they would be able to do such a good job because quick delivery is logistically very challenging. But it is becoming a sort of a space where some players are doing really well, and they're pushing the incumbents to also move and provide like quicker delivery. So now sort of incumbents also are providing those services. So you do see those kind of innovations.
And also this in this regard, we know from generous or more focused media that Indian government was quite active in introducing measures and mandatory kind of requirements with the ownership in e-commerce, or that if you run a platform, a marketplace, you cannot sell your own branded products there in competition with your vertical business users. Can you elaborate on all this? When they have been introduced, did they have a significant impact on the shape and the parameters of providing e-commerce? And did you have similar initiatives maybe in other digital markets which are meaningful and you can reflect upon?
So this is the part of the foreign direct investment regulation in India. It doesn't apply only to digital markets, so to any kind of foreign investment in India. I'm not sure when it was introduced, but it's been around for a long time. So essentially, this is a regulation of what foreign players can do in India. And foreign players can do a lot of things in India, but they cannot provide an inventory-based model, and they cannot do this kind of self-preferencing. So it's kind of like a prohibition of self-preferencing. And I think it's coming from the lobbying from domestic sort of sellers and retailers that will obviously find it difficult to compete with, say, if these players like Walmart come into India and have these huge like grocery stores, where India is a market where you have smaller like mom and pop stores, and those stores are obviously doing well, and they're competing very well with the larger players, but they might find it difficult to compete with sort of the large scale economies of scale based sort of a Walmart type of retailers. So I think it was a response to lobbying from those groups, that there were certain restrictions that were placed on foreign players in terms of the kind of retailing strategy they can adopt in India. So they can only come into India through a marketplace model, not through an inventory-based model. So they can only be an intermediary between buyers and sellers. They cannot buy and then sell to consumers. So they can't directly sell to consumers in a multi-brand format. So if they're just a single brand, then they can sell directly to consumers. But as a marketplace where they're selling a lot of different brands, they cannot sell directly to consumers. They can only be a conduit between buyers and sellers. And they cannot also have, obviously, their own sellers or any related parties to them selling on their platform. So that's the restriction that is placed on them, which is similar. I mean, it definitely overlaps with the self-preferencing type of restriction that is envisaged under the bill as well.
Let us now move to the bill itself. You mentioned when you were outlining the context that the designation criteria and this being targeted by critics of the bill, the designation thresholds are rather low, and 100 companies are potentially designatable. So I obviously understand that it's not about the threshold, it's about how it's not mandatory designation. Yeah, it's optional. So it will be for the commission, for the Indian Competition Commission to designate, and based on some criteria or some vision, perhaps, not only criteria. So not all which are potentially designatable will be ultimately designated, supposedly, because if you have 100 addressees, it would be hardly enforceable, I imagine. Maybe not, maybe you have a different vision. So maybe you can reflect upon the designation criteria in more detail. Did you hear something going beyond the criticism that 100 companies will be affected? Maybe from the opposite side, saying it will be the fewer the better, so to say, or what are the visions there?
Yes, so I think that's a very sort of relevant point, which is essentially that yes, many companies might be designatable, but the CCI, I think, in my view, what the CCI does, it will be very careful in terms of which companies it actually designates. So what the problem is essentially with the way that the notification thresholds have been kind of structured in the bill. And Ulas, I would love to hear your views on this as well, given your experience with the DMA and the DMCC, which is that in the Indian version of the digital competition bill that we have, if you fall within quantitative thresholds, then obviously you have to notify to the CCI. But even if you don't fall within the quantitative thresholds, the CCI can sort of, in its discretion, designate you. Obviously, you'll get a right of hearing, but the CCI can still designate you if you meet a set of qualitative thresholds, which are very broad and very vague. So unlike what you have in other legislations, this is basically a list of anything that gives you any degree of power in the market. And there isn't any guidance about how the CCI will interpret these qualitative criteria, or sort of what they will do. But it is similar to the way that the Competition Act is structured right now, which is also giving sort of CCI, okay, these are the list of factors that you should consider when you're determining dominance, or when you're determining sort of an appreciable adverse effect on competition. The Competition Act is structured in a similar way, but we see that the CCI is very careful in terms of how it interprets these provisions. Obviously, there are cases where you can criticize the CCI. There's almost every case where you could criticize the CCI, but in terms of how it's analyzed these provisions. But as an outcome, I think the CCI is careful in terms of it's not just enforcing against companies left, right, and center. It's very careful about who it's enforcing against. So while its interpretation of the provisions and the jurisprudence, I think individually I have some issues with the way it does it. But as an outcome, I think there is less quarrel with the CCI in terms of who it's enforcing against. And I think in a similar way, the bill is ambiguous in its wording, and therefore there might be discretion given to the CCI. But I think the CCI will be careful in terms of how it uses those provisions. It's not going to use them in a very arbitrary way. I think it's going to stick to the spirit of the bill, which is what the report says in terms of enforcing only against entities that are gatekeeper, like that have systemic significance, that are creating sort of concentrations, and that are sort of acting anti-competitively in markets. It's not going to just apply it to any entity that it wants to. So while the wording of the law is a bit vague in a number of ways, this is just one way, but also the thresholds are low, because this is a comparison with the EU. So they say that in EU, the thresholds for the quantitative thresholds will cover around, say, 10% of the users in the EU, but in India, it's less than 1%. So given India's population, the quantitative thresholds mean that sort of less than 1% of India's population, if you're catering to them, you'll fall within the designation criteria as an SSDE. So that's another criticism. And of course, the opportunity to argue that even though you fall within the quantitative thresholds, you should not be designated as an SSDE is not there in the Indian version of the bill, which is another criticism, that there should be an opportunity to defend that. It's there for if the CCI is designating you without you coming forward and sort of notifying the CCI. If the CCI sort of designates you based on qualitative criteria, or sort of does it on its own, then the CCI has a right to, then you have a right to sort of hearing before the CCI designates you. But if you're meeting the quantitative criteria, you don't have a right under the bill as of now.
No, I think what we have in both EU and the UK mechanisms is large elements of discretion for the enforcers to designate. So it's not automatic. You have to notify, but the designation is not automatic, and I think that's the way how it should be. So it is a selective tool requiring almost kind of surgical precision, because the fact that you end up one step below the designation, the actual designation, means that you become a double beneficiary of the system. A, you are not designated, and B, your direct competitors become designated, and thus you are moving up automatically almost, because they receive a heavy burden of obligations on their shoulders. However strong their shoulders are, it's still an implication. So having it automatically, I think it's just unenforceable from how I would envisage the mechanisms in the EU and the UK. So I fully agree with you that it should be very, very delicate, ad hoc almost opportunity for the Commission, for the Competition Commission of India, to think in which specific case, which specific undertaking should we designate or not. Furthermore, if you go to the UK mechanism, this is less relevant, because the very fact that you are designated doesn't mean anything until we impose upon you conduct requirements, obligations. You are not, it's like being dominant in ex post competition law. Whereas in the DMA, you automatically have to comply with all obligations. Obviously, we presume that the Commission might turn a blind eye and say, okay, we accept your pro forma compliance, which you submit in compliance reports annually, but this is just the first layer of compliance. We will not be problematizing potential, and will not be searching for instances of non-compliance, because we have other priorities. So that would be a way to deal with 100 companies. But I imagine having 100 companies, metaphorically speaking, being subject to the rules would be slightly strange, counterintuitive to me, because I would say that if the markets are entrenched, this mechanism is designed to bring some competition. So it's less about fairness, vertical fairness, it's more about horizontal competition. We have other tools like platform to business regulation, where you would cover, or DSA even, where you would have much broader coverage and impose these requirements which restore some elementary features or basic features of transparency, accountability. But the DMA and the MCC are much more surgical mechanisms, and they require almost micromanagerial enforcement in my reading, but there are other readings as well. So some people want them to be also comprehensive. So, but I would be very cautious with this. So for me, the automatic designation or the automatic requirement to notify is okay, but the implication of notification, the automatic designation, for me, I would say it as a bug, personally. And speaking of obligations themselves, do you have them catalogized somehow, listed, or it's again for the commission to tailor them depending in a bespoke fashion, depending on each specific? I imagine 400 undertakings bespoke would be very difficult to even to design. But so how does Bill offer the solution?
Yeah, so that's actually a great question, Olas, because I mean, one would think that this would be a pretty straightforward question to answer. But when I looked at the bill, it wasn't such a straightforward question to answer, because while the report says that the idea is to have tailored obligations for each what we call core digital service, which is equivalent of core platform service under the DMA. The bill, the wording of the bill is a bit ambiguous. So it says that there are a set of obligations given under the bill that the SSDE, that is the designated entity, has to comply with. But there are also, so the bill also says that a designated entity has to comply with obligations under this chapter and regulations that the CCI will come up with. And I think those regulations are the differential obligations that each entity has to comply with. So, but if you also have to comply with these obligations and also with the regulations, it's unclear whether sort of there is a set of obligations under the bill that you will not have to comply with because the regulations say you don't. So that, and then also there is this concept in the bill where they're talking about, sorry, I'm just going to pull up. So they're talking about conduct requirements, and then they define conduct requirements. So we assume that conduct requirements should be sort of, again, obligations that are tailored to each core digital service. That's what the report says. Not only each core digital service, but each SSDE providing a core digital service. You might have separate conduct requirements for them as well. But when you look at the wording of the bill, there's an explanation to Section 7 that says conduct requirements includes the manner of complying and the timelines associated with compliance. So they're not talking about having different obligations. They're specifically as a meaning of conduct requirements. So I think there is some level of ambiguity in my reading of the wording right now, but also like interested to hear sort of your or other views on how to interpret this term conduct requirements. I think that there needs to be a little bit more clarity in the wording of the bill, but I think the intention is definitely to have separate obligations for each core digital service as well as for each provider of a core digital service. And we have this other concept in the bill, which is associated digital enterprise, which is again a matter of great contention because it's making the obligations under the bill applicable to group companies as well. So a holding company or a subsidiary company or any other member of the group of companies that are also involved in the provision of a core digital service will get designated as an associate digital enterprise, ADE, and they will be subject to conduct requirements. Again, the bill says different set of conduct requirements, but not very clear in the wording of the bill. And they can also be penalized for non-compliance. So that makes the obligations under the bill applicable to a larger set of corporate entities, which is another source of friction from critiques of the bill.
Interesting, because the vocabulary of conduct requirements mirrors the UK regime. So Digital Markets Competition and Consumers Act does have one of the two main autonomous mechanisms of imposing obligations is bespoke conduct requirements tailored specifically for each designated undertaking with strategic market status. So I think in this regard, India opts rather for bespoke UK model rather than category or something hybrid. From what I understand, I will be re-listening your answer, and I'm sure I'll understand better, because I'm now thinking of questions and trying to get as much from the first hearing, so to say, of your answer as well. In terms of this corporate relationship, it's another interesting way. Maybe it's an attempt to avoid circumvention, where you will somehow structurally will try to redesign your corporate relationship and organization in a way which would minimize the designated elements of your undertaking. But in terms of the sectoral issues, it's how it is being offered in the EU mechanism. We have core platform services, and you can be simultaneously a designated gatekeeper vis-a-vis one platform service, but not other, where your main competitor will be designated. So you are simultaneously a kind of a victim and beneficiary of the DM. You might be, if you know how to use strategically, prudently, all the opportunities, which tonality to play, which melody to sing to the enforcers, to the public, in order to escalate a specific issue of non-compliance by your competitor, and maybe to target the attention and limited resources of the enforcer towards that issue rather than your potential non-compliance. And I'm mindful of time, Shilpi, so I wanted very quickly to ask you about the possibility of efficiency defense and remedies. Two different questions, but maybe if you can combine them in one answer.
Sure. So we don't have an efficiency defense under the bill, but we do have certain exemptions from requirements to comply with the provisions of the bill. And this is, I think, similar to the DMA. Again, happy to hear what your thoughts are on this. So essentially, you can get away with not complying with obligations of the bill, or the CCI could, when it's framing regulations, and again, this kind of suggests that regulations will be framed for each SSDE separately, as well as for each CDS, the core digital service, separately. The CCI could take into account factors like economic viability, which I think is there in the DMA, prevention of fraud, cybersecurity, protecting IP rights, or there's a broad catch-all, sort of any other factor, as well as compliance with other laws. So that is what we have. Again, that's a subject of contention, that we should have a objective justification requirement, that sort of an SSD should be able to say that there's an objective justification for what we're doing, and that should allow them to be exempt from obligations under the bill. So that's not there, which is the critique. In terms of remedies, what we have essentially is obviously penalties, and the penalties are based on global turnover. So that is a high threshold, so 10%, or the maximum is 10% of global turnover, which is a high threshold. But beyond penalties, also penalties for individual managers. So that's something additional that we have under, I'm not sure it's there in the DMA, individual penalties. And that's also been a subject of criticism, that how will you determine sort of individual liability for individuals within an SSDE, and how will you penalize them? So that is there. And then behavioral remedies are there. So obligation to change conduct, to stop conduct that does not comply with conduct requirements or obligations under the bill. But we don't have structural remedies under the bill. So that is, I think, something that's there under the Competition Act, but not there under this bill, which is, I think, a drawback.
I would say that efficiency defense is acceptable if it's not mandatory. So I would give, if you give the enforcer the discretion to say, tell me what is your defense, and then you have the flexibility to say, interesting, we will think about it, and then it's not justiciable somehow. You cannot challenge the validity of your decision to accept or not accept efficiency defense. So making it informal is a great opportunity to make the regulatory dialogue, which underpins the whole issue of this ex ante mechanisms, very informative, and it would encourage undertakings, designated undertakings, to bring evidence which are not just 1,000 pages or very technical, but which would be really meaningful. But if you have it mandatory, as we have in the DMCC in the UK regime, for one of the two autonomous ways, then it can be used for different strategic delaying purposes at the very least. So you wouldn't expect to win the case, you would expect it to delay and shift it from the enforcer to the judge. And the duty of the judge is not to make digital markets functioning better. The duty of the judge is to police the compliance with the rule of law, at least the primary duty. And that's a different issue. So to depoliticize this thing. So I think that in this regard, having efficiency defense is like, you want to have a cake and eat it. If you want to think about efficiency, the DMA is not for. So that's my understanding of things. And maybe a last question on substantive issues. Enforcement. Do you see this the CCI would have a significant discretionary power? What would be its communication with the government? Should it inform the government? Should the government inform of its strategic vision, maybe somehow nudging or giving a hint about where the priorities should be placed in terms of being more vigilant and on one activity or one player or the other? These are crucial issues. I imagine it would be hard to thematize before the legislation is being introduced, but maybe you heard something about it.
Yeah, so I know we are running out of time, but also just quickly on the defense, right? So just a few thoughts I had. One is that in digital, especially, right, a lot of the defenses that we get from big tech are defenses that are hard for enforcers to verify. Because say if you're saying, big tech is saying we need to do this for security, for instance, with restricting third-party apps, there might be a point to it, but it may not be entirely technically correct. So much of it is based on the state of play of technology, right? What you can do from a technical perspective. And if we are just reduced to accepting what big tech is saying from a technical perspective, and then accepting that as a defense, when we know that a lot of this is actually not entirely technologically correct, then that becomes a limitation of this kind of defense that gets mounted, because it might be restricting our view of what is possible, because we have to take what they're saying and we can't really question the technology of it to that extent, or have some kind of mechanism where there can be a technological dialogue in terms of what is possible and what is not possible. And I think under these kind of regulations, you can have more of a technological dialogue, whereas under ex post enforcement, you can't really have that. So I think that's another issue. It's also one of the things that I'm struggling with, because so many of the critiques of the bill are saying that, look, we need this for security, we need this for privacy, but technologically, that's not entirely true. Or at least we need to have a broader discussion of technologically whether that is true, whether you really need to restrict third-party apps, for instance, for security or privacy reasons. Like, what is the level of restriction? That's another thing with respect to interoperability. So we don't have interoperability in the bill, which I think is such a key to the Indian digital agenda, but it's not there in the bill. I'm not sure why it's not there in the bill as an obligation. But again, there are sort of arguments against interoperability on some of these grounds, which I think we need to have broader dialogues around in India. So having said that, coming to your question, I think so. Also, so given the level of criticism that the bill is getting in India, I think there have been a number of stakeholders coming and complaining about the bill. There were news reports. So the bill has come from the Ministry of Commerce. Now, there are news reports that the Ministry of Information Technology is hearing sort of arguments against the bill. They're hearing the views of stakeholders and issues around the bill. So I'm also very interested to see sort of how these different ministries will kind of interact with each other and what's going to happen to the bill, given the different regulators who have an interest in the regulated entities who will come within the bill, as well as the different politics at play. But the bill itself does envisage some level of government involvement. So, for instance, the government can step in and sort of in certain situations, sort of say that these obligations will not apply, etc. There is some provision in the bill for regulatory dialogue as well. So, sort of with other regulators, the CCI can consult with other regulators can consult with the CCI. So, but not the same sort of in the same structured way that we see in the DMA. So you don't have any structured sort of element of like, okay, everyone is going to come together and give their view on anything. But there is some provision for a regulatory dialogue. And I think just as you mentioned, this is digital markets are going to become increasingly the way that most markets function, will have some element of digital in them now. So it's not going to be a niche market, it's going to be economy wide. So there are going to be obviously a lot of interests at play, a lot of regulators who will be involved. So this is going to become more and more significant. So I don't think it can be viewed in a very niche way. And I think if the bill envisages it to be a very niche kind of regulation, even though you have a set of core digital services, with the coming of AI, it's going to change how digital is interpreted. So it needs to be a much wider collaborative effort.
And this gives us another opportunity to reconvene in 2025 and to look at its implementation and the first designation cases and the reception in society. Let us finish today's conversation with your recommendation to students.
Thank you, Ola. I think we've talked so much. Maybe one thing I would tell students is, this, just as the way this discussion kind of reflects, there's so much going on in digital, and there is so much of scope for making contributions. But I think it's hard sometimes, at least what I see with my students, it's hard, like with all the information that gets thrown at you, to kind of make sense of that and to have your own voice and your own views on those perspectives. So I think it's important for students to always like take a step back and don't let all the information that's getting thrown at you kind of overwhelm you. I think this is a space where any view that you have is a valid view. So don't get stressed by all the things that get thrown at you. Always like take a step back and take a broader approach, look at the different views, and then try to formulate your own view.
Shilpi Bhattacharya, thank you very much indeed for this illuminating conversation. It is always a pleasure to meeting you and to learning from you. Thank you.
Thank you so much, Ola. It was great being here.